This award is made in an arbitration between the Tokyo's Tokeles versus Ukraine in accordance with the dispute resolution mechanism of the International Center for Settlement of Investment Disputes, dated 8 of February 1984 and entitled Agreement between the Government of Ukraine and the Government of the Republic of Lithuania for the Promotion and Reciprocal Protection of Investments between the Republic of Lithuania and Ukraine. The claimant in the arbitration is Tokyo's Tokeles, a corporation registered in 1989 as a cooperative enterprise under the laws of Lithuania and subsequently reorganized as a joint stock company. The companies most immediately involved in the events giving rise to this arbitration were its two wholly owned Ukrainian subsidiaries, Subsidiary Enterprise Tokeles Private and Tokeles Private 2. By the beginning of the year 2002, Tokeles Private had for some years carried on a prospering business in Ukraine in the advertising, printing, publishing, and allied trades under the control and management of two brothers. Both are citizens of Ukraine and resident in that country, apart from a period of some years commencing in May 2002, when Mr. Danilov left Ukraine for Lithuania, where he saw and obtain refugee status. This has proved to be a difficult case so much that after prolonged and intensive discussions, the tribunal with regret finds itself unable unanimously to agree on the central issue in the dispute. This proposition is that Tokeles Private was the target of a long-running campaign of oppression by the state agencies, instigated for political reasons by high authorities and taking the shape of numerous episodes of unjustified interference with Tokeles Private activities and management, largely by the Kiev tax administration, but with the convenience of prosecution and judicial organs, under the guise of investigation into breaches of Ukrainian economical laws. Justice required that the issue of jurisdiction should be reassessed in the light of this new information, and it was decided that the submissions and conclusions upon this would be incorporated together with the issues of liability and quantum. Claimant's case. Tokyo's whole argument is based on political basis, exposing Ukraine's government power over corruption on political matters. Therefore, we're going to show you some important arguments that build up the case. Tokyo's Tokeles claims in the given case concerns actions committed by the state agencies of Ukraine which are connected by a unity of wrongful intent and purpose on the part of the government officials of interfering with the business of Tokyo's Tokeles wholly owned subsidiary in Ukraine, Tokeles Private. This goal of intentionally damaging Tokeles Private was realized through various measurements implemented by state agencies of Ukraine in order to ultimately achieve an illegitimate political goal, namely to punish Tokeles Private for supporting an opposition political, Yulia Tymoshenko. The entire series of acts by state agencies of Ukraine with regard to Tokyo's Tokeles investment in Ukraine, specifically in its investment vehicle Tokeles Private, is rife with violation of the BIT, Ukraine's laws and international law. These acts and their attendant violations comprise a single whole, which consists on the intentional, premeditated destruction of Tokeles Private's businesses and operation and its reputation. That is, a wave of repressive actions against Tokeles Private began immediately after Tokeles Private printed a large amount of campaign material for Yulia Tymoshenko, provides convincing circumstantial evidence that the authorities vented their wrath on Tokeles Private precisely for its support of an opposition political. What does matter for the purpose of the treaty is whether there was malicious campaign, and if so, whether it can be attributed to the respondent state. For this purpose, the tribunal must, in practice, form an idea necessarily based on secondary and circumstantial evidence, since direct evidence is out of reach, not so much about the identity of the prime mover, but about whether it was a person or group of persons whose actions were, for the purposes of the treaty, those of the state. In the claimant's narrative, we have a question of inference requiring a choice between two fundamentally different narratives. One, represented by the claimant, describes the interaction between Tokeles Private, its officers, and the STA. The other views the story in the context of investigations carried on by state agencies at and around the time in question, and whilst not directly challenging the claimant's bare recital of events, treats it as an incomplete and potentially misleading. The way in which the claimant has formulated its case requires the tribunal to reach conclusions on a. what happened as between the STA and Takis Privy, and B. Why did it happen?
The relevant legal provisions. In reaching its majority decision on jurisdiction, this tribunal is guided by Article 25 of the ICSID Convention as well as Articles 1 to 8 of the Ukraine-Lithuanian bid. Also, the Article 25 of the ICSID, Article 8 of the Ukraine-Lithuanian bid, Article 1 of the bid defines investment, the Article 25 of the Convention, insufficiently evidence, and which were consequently dismissed by the courts, and cases in which the executive agency were allegedly able to exert pressure on judges to adopt decisions which were contrary to the facts and the law. First, the state had no attempt to put forward its own version of the events. Second, in response to the claimant asserts in the General Procurator which to exert pressure on Tokio Tokeles, it could have done so since it held to power to respond criminal case. And the third one, the Central Election Commission of Ukraine, as directed by the current legislation, authorized the tax services to check information about violations of election legislation during the manufacture of printed production by the election bloc of Yulia Tymoshenko. The claimant's formulation of breaches. The events that summarize were infringements of the following provision of the treaty. First, Article 2, Promotion and Protection of Investment. 2. Article 3, Most Favored Nation Treatment. Article 5, Expropriation. The claimant contends that during the period 2002-2003, Ukraine committed the following violation of the applicable legal norms. The tribunal's finding. First, for climate, the timing of the state's action against Takis Pravi, which began just days after the company delivered campaign materials to bid, is consistent with political motive. Second, further, the magnitude, character, and duration of the state's investigation, as well as, in certain respects, its manifest lack of factual or legal foundation, are also consistent with claimant's argument. And third one, that evidence indicates that the action against Takis Pravi were the results of an investigation of company with which Takis Pravi did business that began before Takis Pravi produced materials for bid.
The tribunal orders as follows. First, the objections by the respondent to the jurisdiction of the tribunal are dismissed. Second, the claim of the claimant for breach of Article 5 of the treaty is dismissed. Third, by a majority, the claims of the claimant for breach of Articles 2 and 3 of the treaty are dismissed. Fourth, each party shall bear its own legal costs and expenses, and B, each party shall contribute one half of the cost proceedings.